Hello and welcome to Talking Points. I'm Dave Kelly, Director of Advanced Media Production at Cal State Long Beach. Today we're going to focus on the Second Amendment and how the Supreme Court has ruled on the people's right to keep and bear arms. My guest today is Dr. Craig Smith. Dr. Smith is the former director for the Center of First Amendment Studies. He's also a professor emeritus in communication studies, and he also was a speechwriter for Gerald Ford. Welcome, Craig, and thank you for joining us on Talking Points.
Nice to be here.
Well, as we talk about the Second Amendment, we should probably acknowledge here at the beginning that there have been two relatively recent rulings where the Supreme Court has declared that the Second Amendment affirms the individual right to own guns. We're going to talk about that more in a moment, but first let's take a look at the actual amendment itself and what the exact wording is. So we have a graphic that we're going to put up on the screen now so that you can see what it says. And in fact, the Second Amendment is written to say a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so very short amendment, but caused a lot of debate and argumentation over the years. We have a prefatory clause, which means a preface in the beginning, and that's the part that says a well-regulated militia being necessary for the security of a free state. That sets up the second part, the operative clause, which is where the actual right is defined. And of course, the right of the people to keep and bear arms shall not be infringed is the operative. So let's go to the prefatory clause where it says a well-regulated militia. At the time this was written, when the founders wrote the Constitution, what did they mean by the term militia, and what did they mean by well-regulated militia?
I think we can take it to a very specific example. There was a rebellion, a tax rebellion in western Massachusetts led by a man named Dennis Shay. The rebellion lasted from 1786 to 1787, so it's right before the Constitution was ratified. The Bill of Rights, as you know, was not ratified as part of the Constitution until 1791. So this is a relatively close example. The state of Massachusetts did not know, this is under the Articles of Confederation, did not know what powers it had to raise a militia to put down the revolt. So they appealed to Alexander Hamilton, who was going to be coming in as the Secretary of Treasury, for some guidance. And he told them that they could form a militia. Now, you couldn't be in a militia unless you owned a weapon. And so the right to bear arms was a way of making people eligible to be in a militia. And this was a state militia that then put down the rebellion of Shays. He actually was killed at the end of the rebellion. Then the Constitution was ratified, and the government was formed in 1789, and amendments were submitted from the states. And one of the amendments was from Massachusetts, and that is, so that we can form a militia, let's make sure that Congress can't restrict the people's right to bear arms. And so I think that's the context of that lead-in preparatory phrase.
Okay, and so when we talk about the militia, you've mentioned that this people had to own guns in order to be part of a militia. No point in being the militia if you don't have a weapon.
Right.
So who was eligible to join the militia?
It was anyone of age, and that would have been 21, but in practice, if you had to form a militia, the state often let people who knew how to use a gun enter the militia. One of the people that was killed was one of the people I descended from at Concord, and he was only 16 years old. So they violated the age rule consistently, but they needed that because of the rebellions that continued to occur.
Right, and so generally speaking, the militia was white males at that time, between the age of about 18 and 45 as a general rule?
Yes, that would be right.
Okay, but women were not allowed to join the militia?
No, they were not.
Okay, and so when we talk about the security of a free state, that, as you have mentioned, referred to Massachusetts, I think, in that particular reference, but could that be interpreted, the term state, could that be any state, or could it also be the national or federal government in that case?
I think they're trying to help the states out because of Shays Rebellion. There were two more rebellions, both of them in Pennsylvania, right around the same time as the Second Amendment was being ratified. There was the Whiskey Rebellion, which was a revolt against a tax imposed on whiskey. And that rebellion was put down with only 10 federal troops, but the Pennsylvania militia that was formed. And then later on, in 1799, there was Fry's Rebellion, and John Adams again sent minimal federal troops, and the state had a militia and put down the rebellion. So my reading of the Second Amendment is it's an empowerment of the states, guaranteeing that they can have militias and that the federal government can't prevent them from forming militias, and that's why citizens have the right to bear arms.
Okay, so when it says free state, that literally means the states that were in the colonies that
Yes,
became
I
states.
think so, yes.
Okay, and so when we go to the operative clause, which is the part that says the right of the people to keep and bear arms, and then the declaration that this right shall not be infringed, when we talk about people, that's been the people, the phrase the people, that's been an issue of debate as well. What did it mean by the people? You're talking about, was it people that were only in the militia, or was it all people, or how exactly would you interpret that?
I think because it says the people instead of individuals, it could have said citizens. If you go to the First Amendment, it says freedom of the speech. It doesn't say freedom of speech. When they put the in front, it was a specific qualifier that meant people who were eligible to be in the militia, in my opinion.
Mm-hmm. All right, now actually, as we look at the way this is written, it has kind of a backward syntax to it in the way we read it today, because you put the well-regulated militia part in the beginning, but you get to the point of the whole amendment in the second half. I would suggest, and this is my opinion, that if we were to write this today, we would write it in this manner: the right of the people to keep and bear arms shall not be infringed because a well-regulated militia is necessary for the security of a free state. So if you take us back to that time period, why did they write the amendment with the so-called backwards syntax, which is rather clumsy as we read it today?
All of them have been educated in classical rhetoric, and mainly that came from Cicero's books on oratory. They were very popular in the schools, and they had been translated, and that's how rhetoric was taught. And Cicero was very talented as a senator and as Consul of Rome at giving great speeches. And one way he held the audience's attention was to enter into an abnormal syntax. That then became part of British parliamentary procedure, and also the founders of our country inherited that habit of doing that. And I think that Madison's wording of this amendment reflects Cicero's "let's keep the attention of the audience." I think also we need to understand that at the time, I think the meaning was very clear to them, and they didn't think about how that syntax might confuse people 200 years later.
Okay, well, let's take a look at the Supreme Court rulings that I referenced in the very beginning. There were two of them. One was in 2008. That was the case of District of Columbia versus Heller, commonly known as DC versus Heller. And then the second one was McDonald versus the City of Chicago in 2010. Now, in the first one, in DC versus Heller, that was the opinion, the majority opinion was written by Justice Antonin Scalia. And his interpretation of the Second Amendment in that case was that there was a natural right to self-defense. That being the case, the natural right of self-defense gave individual people the right to defend themselves, and the way you defend yourself most effectively and most logically is with a weapon, and that would typically be a handgun. And so he also suggested that the term "the people," his interpretation of the people was that it was individual people, not necessarily those involved in a militia. And of course, citizens of that day were called into the militia, but that was not the only reason why they needed a gun. They needed a gun for not only self-protection, self-defense, that natural right of self-defense, but also for self-preservation in terms of hunting for food, because in those days, many people were hunting for food. And so if that's the case, that's different from past rulings, and if so, how was this different from past rulings by the Supreme Court, and how did this interpretation of the individual right differ from those past rulings?
Well, in 1939, the Supreme Court gave the states the right to regulate, and that had been their interpretation, and it's the one we've been talking about up until now. Mm-hmm. One of the things that Scalia wrote about was the right to self-defense. It would be nice if that had been in the Second Amendment, but the Second Amendment says nothing about self-defense. Mm-hmm. So I think he's wishful thinking. Now, if a state wants to establish it that way, I think the Second Amendment protects the state to do that. But it doesn't say that the federal government can now come in and say everyone has a right to bear arms. I think it's wishful thinking on his part. He was a hunter, and that was one of his habits. I think it may be logical for people to be able to defend themselves, but that's not in the Second Amendment.
Also in the Heller ruling, Antonin Scalia did not say that all guns were available at all times to citizens. He did put some restrictions on the types of guns and also place where guns can be, present. For example, he specifically mentioned schools and government buildings and so on as places where you could prohibit guns, and government buildings, schools, etc. And also he had restrictions on the kind of folks who could get guns. Mentally ill people could be excluded, felons could be excluded, and also in terms of the types of guns, he did refer back to that case you just mentioned, which was United States versus Miller, which was decided in 1939. In that case, there were a couple of criminals who were trying to traffic sawed-off shotguns across state lines. It was litigated, and ultimately the Supreme Court, as you said, ruled that the states can regulate guns, because if those guns aren't even necessary for militia, and a sawed-off shotgun is not something you'd bring to the militia, and also it's mostly used in criminal actions, so it's not necessary to have that. So Scalia did refer back to that and say, yes, there can be some restrictions on the type of guns. Gun advocates have said Scalia left too much wiggle room. Do you think that he gave us, Antonin Scalia, in this ruling enough clarity on what he meant, or are we going to continue to see litigation?
I think there are common sense restrictions that we have put on amendments. The First Amendment says we have freedom of speech, but you can't sell obscene material. You can't libel or slander someone. You can't commit defamation. You can't commit treason. So you can't shout fire in a crowded theater unless there's a fire. So there are common sense restrictions on the First Amendment, and I think he's talking about common sense restrictions on the Second Amendment, and I'm more sympathetic to him there than I am about his universal right to bear arms.
Okay, and on that note, we're going to go to the break. When we come back, we'll pick up this discussion and talk about McDonald versus City of Chicago. And stay with us. When we come back, we will pick up this conversation and we'll continue in discussing how the Supreme Court has ruled on the right to keep and bear arms. Stay tuned.
Make a difference in our future by researching and helping to preserve our natural resources. The wide variety of careers in this field will have a huge impact on our lives while using the principles of engineering, chemistry, and biology to help find solutions to environmental problems. You could be a part of this exciting field with a degree from Cal State Long Beach.
Welcome back to Talking Points. I'm Dave Kelly, and my guest today is Craig Smith, and we're talking about the Second Amendment. Craig, when we left, we were finishing up with the case of D.C. versus Heller. Another case came up a couple years later, which was decided in 2010. That one was called McDonald versus the City of Chicago. In this case, it was a citizen in Chicago who was living in a very troubled neighborhood. Yep. Wanted to have a gun for self-protection. He'd already experienced a couple of burglaries and lots of crime in the neighborhood. And he found that the permitting laws and such in Chicago were so restrictive that it was almost impossible to acquire a handgun for protection in the home. So he again appealed his rulings to all the way to the Supreme Court. And the Supreme Court ruled this time similarly that they did in the first case of D.C. and Heller. This time the justice writing the opinion was Samuel Alito. And what he determined in that case, Justice Alito's opinion said that the 14th Amendment due process clause would apply to keep states, cities, local governments from passing laws that would make gun ownership so onerous that you could never get through the Byzantine rules. What do you think about this with the 14th Amendment due process clause? What does that mean, and how does that also support the previous ruling?
Well, the 14th Amendment has been used by the Supreme Court to pull through the Bill of Rights and apply them to the states. Mm-hmm. In this case, Alito pulled it through but applied it to individuals. My ruling would have been different. My ruling would have been the city of Chicago has no authority to do this, only the state does under the Second Amendment because of the allocation of militia formation to the states. It seems to me that that implies that it's up to the states to regulate. So you can't have a city overruling what the state would do. But in terms of the individual having a right to self-defense, again, I don't see it in the Second Amendment. That's what people have been saying is a common sense way to go with the Second Amendment, but it's not there.
Given that we've had these two rulings back to back, and that usually the court follows precedent when they consider future cases, do these rulings mean that the individual right to own a gun is now a constitutional right and it will stay that way for the foreseeable future?
It is a right now under these rulings, but these were 5-4 rulings. And so all it would take is one justice changing their minds. Under the doctrine of stare decisis, or precedent, the more justices that rule in favor of something, the stronger the precedent. So in Brown versus the Board of Topeka, which integrated the schools across the country, that was a unanimous decision, so it was a very strong precedent. These two cases are not very strong precedents. They're as narrow as they could be.
All right, if we look at what's happening today with the Supreme Court, there is a case that's most likely going to be declared moot because the actions that caused the case to come to the Supreme Court have been adjusted and corrections have been made by the City of New York. This case is called the New York State Rifle and Pistol Association versus the State of New York. Now, the City of New York,
right.
New York City. And so what New York City had done was it had applied the most narrow possible interpretation of those previous rulings, and they basically had to acknowledge that, okay, people have a right to own a gun in their home for self-protection. However, they made so many other rules around that so that you couldn't actually take the gun out of the home. It was very difficult. And you could be charged with a criminal offense if you transported the gun outside of city limits to go hunting or to go to a gun show or to go to a gun range, etc. And so it was, again, the most narrow possible interpretation of DC versus Heller and McDonald versus Chicago. But when this came up to the Supreme Court, the City of New York got cold feet. They withdrew and repealed that particular law, and the state of New York then passed a subsequent law preventing that from coming back up. Now, because of that, because of the way this played out, I mean, the Supreme Court is probably going to say, well, there's no issue anymore. It's essentially been resolved.
Right.
But because of that, there is now a gun sanctuary movement. People in states all across the country that are gun owners and gun activists have now started creating local ordinances for the counties that provide quote-unquote sanctuary for gun owners. And in Virginia, where this is a very hot issue right now, 90 of 95 counties have passed these ordinances, and the movement is spreading to Illinois, to Colorado, to Kansas, and so on. What is your thought about the sanctuary gun movement? Where is it going? And is really the heart of this conflict a difference in philosophy between those that want to essentially ban guns altogether and gun rights activists who want a wide open interpretation of the Second Amendment?
Well, let's go back to where we were before and my interpretation of the Second Amendment, and that is it empowers the states to control weapons. So cities shouldn't be doing that. New York City withdrew. The state of New York rightly overruled them. If they could get the Supreme Court to rule that the states are in control, that would end any of the cities interfering with guns, and it would also end the sanctuaries that are being formed, which I think are unconstitutional. I don't think that a county can do that under the Second Amendment, but it has to be interpreted the way we originally talked about it, and that is that the state is in control of these regulations.
Okay, and so is the conflict between people that want to ban guns altogether and those that want the most latitude possible within the Second Amendment?
I think there's probably a philosophical difference. I think the people who want to have the right to bear arms, who want to set up sanctuary areas, remind us of the Bundys and other people who've revolted against the federal government. These people are revolting against their state governments. But if we go back to the 3 rebellions I talked about earlier, around the time of the First Amendment, the federal government empowered the states to form militias to put these things down, and therefore I think the people with these libertarian tendencies are wrong about what the Second Amendment allows them to do.
Okay, well, let's move along to another area of gun regulation, and that is the permitting of concealed carry permits. And that's giving people who apply for a permit the opportunity to carry a gun with them at all times, and it can be concealed, obviously. So there's been a big debate about this, whether that's a good thing to have concealed carry or a bad thing. The people that say it's a good thing say, well, self-protection is necessary everywhere. People that are against it say, well, having guns on everyone everywhere could cause havoc and chaos at any moment, at any time. However, where the concealed carry laws are in effect, in those counties, there's been some research done by a researcher named John Lott, who's written a book called More Guns, Less Crime. He's done extensive and very thorough research, and it's hard to argue with his results, but his results do indicate that in those places where concealed carry is practiced, murder rates are down 8%, rapes are down by an average of 5%, aggravated assault is down by about 7%. Now, if you go to the higher crime areas where crime is higher than the median, the murder rates were down by 10% and rapes down by more than 7%. So, assuming that his statistical analysis is accurate, isn't that a strong argument for concealed carry? And is there an effective argument against it based on facts and not just an emotional reaction?
Right. I think he applies a cost benefits analysis, and I think it's very sound. I don't doubt his statistics. But those statistics could then be taken to the state, and the state could pass a law. In Kansas, they have a concealed carry. I just lectured at the University of Kansas, and when I was told that there were probably students who had concealed weapons on them, it certainly chilled my speech. I think that's one of the downsides to it. The other cost benefits analysis that I think people need to look at is the odds are, if you have a gun in your house, that it is much more likely to result in domestic violence or a child killing himself or killing one of his playmates than it is to prevent a burglar from coming in the door. So on a cost benefits analysis using his method, you would ban guns from being in a house. And that would, again, defeat the whole purpose of where he's going. I think that he just needs to make his argument to the states. The states can then determine how they're going to carry that out and deal with it.
Okay, and in the case of crime, John Lott does acknowledge through statistical analysis that even though violent crime is down with concealed carry, he found that property crime and nonviolent crime actually went up on the other side. And the reason for that is because criminals who have criminal intent don't want to confront people that have guns for obvious reasons. They don't want to be shot. Yeah. And so if they do have criminal intent, they adjust their pattern of crime and they focus on stealing unoccupied cars, not carjacking, but unoccupied cars, and other kinds of theft which don't involve confronting people. So in that case, it's not a solution for all crime, but in the case of protecting one's home, other statistics do support the idea that if you have a gun in the home and if it's well known that that particular area is well armed, break-ins are much less than they would be in other communities where it is not known where guns are available. So in that case, I guess, does that mean that guns in the home do support the rationale that was used by both Scalia and Alito in the rulings about self-preservation?
Yeah, I think they do, and that's just, states have to deal with that and determine what their citizens want. If we're going to allow guns, I think one way to deal with them is to have them fingerprinted, and there are two ways a gun can be fingerprinted. One is that you have to put your finger on your gun and no one else can. That would prevent a child from picking that gun up or somebody stealing it and then using it. The other way to fingerprint a gun is to shoot a bullet through the gun and then take the bullet head and register the riflings and trace that back to you. So if you lost the gun or you sold the gun to somebody else, you'd sure as heck want to make sure that you reported it to the Federal Bureau of Investigation, which could maintain these files.
Has there been opposition to that concept, and if so, why?
I think some extremists in the NRA don't like it because if the government can know where the guns are, then they can come take them. I hate to disillusion the NRA, but if somebody wanted to take that gun, they could do it. The government could do it, and you couldn't do much about it, as the Bundys learned. But that, I think, is the philosophy, that if the government knows where the guns are, then the government can confiscate the guns.
Okay, and this brings us up to probably our last question, and that is in regard to where our society is today in terms of the overabundance of guns. I think it's pretty well known that there are many, many guns out there. And one of the concerns that people have is that, well, if we pass a lot of gun restriction laws, the only people that will abide by those are the normally law-abiding people in the first place. And we don't so much have a problem with law-abiding people with guns, it's the criminals and the people that use guns for mayhem. And so people that have criminal intent aren't going to follow the law anyway, and they will have the guns and they will make everyone else victims of their criminal intent. How do we address that issue?
Well, we have lots of laws on the books that good people abide by and criminals don't, and we just have to enforce the laws as best we can. I think there are ways of making sure that people who commit crimes with guns are brought to justice much more quickly than is now the case in our justice system. Certain kinds of crimes, I think, should be prioritized in terms of others, in terms of getting these things through the court system so that people know they're going to be punished if they violate the law. That's going to be the deterrent.
And on that note, we do have to conclude the program, but I want to thank you for being here today.
Thank you. It's good to be here.
And thank you for joining us on this edition of Talking Points. Be sure to join us again soon for the next episode. Until then, I'm Dave Kelly. Have a nice day.